sia per le sue conoscenze su queste tematiche che incrociano il diritto penale, la procedura penale, il diritto internazionale, il diritto amministrativo, il diritto costituzionale, il diritto dell'Unione Europea. Beh, voi che come tutte queste competenze in una sola persona, vi posso dire che è proprio così. Vervale rappresenta un giurista completo che va oltre le partizioni accademiche che sono invece presenti purtroppo in maniera eccessiva nella nostra professione. Anche per questo, perché per quest'unità umane, ha nel corso degli anni svolto un ruolo di globalist, perché si può trovare nei incontri nativi del mondo e alla fine è in grado di parlare del migliorino della regione andina, così come dei ricci di Montego con la stessa competenza, ve lo posso assicurare. E quindi soltanto un atto di amicizia, di riconoscenza per aver accolto questo nuovo invito che il Ministero di Palermo e il gruppo di ricerca come partecipo che ha rivolto, qualificando questa ulteriore ricerca con la sua particolare
bene? Di nuovo qua, grazie per l'invito, Vincenzo, grazie per i amici ieri sera. No, è sempre un piacere venire a Palermo, tanto alla facoltà come alla città, vista la storia della Sicilia, la storia di Palermo, è sempre così. Grazie mille. Mi hanno chiesto di fare il mio contributo oggi in inglese. Se c'è qualsiasi problema di terminologia, se parlo troppo veloce, se volete intervenire con tutte le libertà. D'accordo? So the first thing I will do is a very, very short introduction of the topic, because you already did it to a certain extent. And then I will explain why I have chosen, in fact, two subtopics of this area. I think it's very obvious that if we look at the Code of Criminal Procedure, and we look at gathering of evidence, 30 years ago, it was of course about interrogation, search and seizure, so a lot of, let's say, contacts with the suspect, contacts with third parties, and then gathering real evidence on the ground or documentary evidence. Today, digital evidence is everywhere. I think it's very difficult to find criminal cases where digital evidence does not play a role anymore. It's just the opposite. I give you a very concrete, maybe stupid example. You might remember that in the city where I'm living, in Utrecht, there was a terrorist attack some weeks ago. A young man did shoot on the tram and killed 4 persons. The first thing the police did was finding out in less than 10 minutes if he had bank accounts and if he had a mobile phone. So they got in contact within minutes with the banking world and with service providers of telecommunications. And they asked both of them to survey in real time all his actions. Because the person escaped and they could not find him. They arrested him in 3 hours because he was so stupid to transfer money from one of his accounts, not with his mobile phone, with a mobile phone of a friend. Then he was clever. But of course his bank account was already under surveillance. All this is digital evidence. And it led to his arrest, and of course it will lead also to be important also for his prosecution. So we have a digitalized society. We have cloud computing for many services. I come back to that. The cloud means in the cloud, so not linked with territory. We have the Internet of Things. It depends on your home setting and maybe also university how many Internet of Things you have. But today, you know, if you have a thermostat to adjust the heating in your home, or you have a new refrigerator, these are mini computers, and they can be hacked, like your own computer. These are Internet of Things. So it gives you access to a lot of what is happening in your home or what is happening at your workplace. We have, of course, an increasing setting of digital platforms for all types of transactions, from Amazon to Uber. We have the blockchains. We have smart intelligence coming up in the digital world, and so on and so on. So all this environment makes that data play a very important role in everything, and that data will play an increasing role in criminal law and criminal procedure. There's no doubt about that. So digital evidence is already very important and it will only increase. When we speak about data, in fact, there the problem starts. Why? Because there are many types of data. And even the specialists in this world do not agree on the definitions and the consequences of this data. Some make this distinction between stored data and non-stored data. Stored data that already exists and that you just can access. Non-stored data is mostly linked to surveillance, so that are produced while you are surveilling the data. Then others make distinctions between content and non-content data. So it's like in the old constitutional concept of a letter, what is on the outside of the envelope or what is inside, that's the content. So what does that mean in the digital world, of course? We will see that it's not so obvious. Then, of course, you have subscriber and access data. If you open an account, and of course, then you get a VIP address, and you have the traffic data. If I send an email or a WhatsApp to someone, this is from point A to point B. So traffic data, transactional data, and then, of course, you have the content. If I'm speaking in a WhatsApp, of course, there's a message. If I'm sending an email, there's a message. This is just content. So you see, this is a very different types of data, and of course, I think you're conscious about that. The impact on your private life, and the impact on your civil liberties is very different when it's only about the subscriber's account or when it's about the real contents. Nevertheless, it's not always so clear. I just give you two examples. If the police is sending you SMS on a regular basis to your mobile phone, and we call that steal SMS, you cannot see that you receive a message. So they're sending SMS to you, and you're not aware that they're sending that to you. Even if you have closed down your device, it can be activated, you don't know it, and you receive the message but you cannot see it. If they do it every 5 minutes during a month, this is just about location. Only location. They're not interested in content. They just want to know, of course they suppose that you're running around with your mobile phone, they just want to know where you are. If you do that a whole month, every 5 minutes, you can build up a quite concrete idea of your life. And it's only about location data, which as such has not a huge impact on your private life. So it depends what they do with it. Okay. My last introductory remarks, and this is also already linked to the choice of my two topics that I will illustrate in a moment. In the web, or the internet world, or the digital world, of course, is very contradictory. It's the world of free communication and free access, which of course has tremendous advantages, but it's also a dark world. So it is bright and dark at the same time. What do I mean with that? I mean that a lot of what is happening in the digital world is happening in increasing anonymity. That means that the users are hiding their identities, for good or bad reasons. They use VPN in order to hide identities. They use Tor devices in order to hide identities. They hide their IP addresses. And it's very easy to get on the market, also on the illicit market, devices for doing that. Some of them are extremely sophisticated and expensive. Some of them are very cheap. And of course, they're sophisticated, so that means easier to hack. But if you buy really a very expensive one, also for the law enforcement authorities, police, prosecutors, and so on, it's very difficult to hack the systems and to get the real identity out. Second, a lot of the communications are encrypted. So that means even if you have access to the devices, to the machines, to the internet systems, and so on, and even if you have access to the messages, you cannot read it. At least you cannot understand it because it's encrypted. So that means that you need devices to decrypt it. And also, that can be easy and can be as good as impossible, because there are very sophisticated software in the market for encryption. Third, The internet world is not bound by national jurisdictions. It's de-linked from territory, certainly with cloud computing. Criminal law enforcement is, of course, built up with the basement on national jurisdictions and a system, I come back to that, of cooperation. So there's a big gap between this free world without any limitations and, of course, the boundaries of criminal jurisdiction in our setting. And it's, you know, when we go to claim jurisdiction for a criminal law investigation or for a criminal law prosecution, we need, of course, a nexus with our criminal justice system. The nexus can be territory, that's here difficult. It can be the nationality of the perpetrator, it can be sometimes the nationality of the victim, but that's always in this cloud world, it's not so easy. And so, I come back to that, when prosecutors, policemen, agencies are investigating this type of crimes, or investigating ordinary crimes where they need digital evidence, then of course, yeah, they are bound normally by the national jurisdiction. They cannot go as a worldwide. Okay. What I will do, I will comment upon the instruments that Annalisa has mentioned. So these are instruments that are still under negotiation at the Council of Ministers in the European Union. This is about a European production order and a European conservation order. In Italia, Ordine Europei di Produzione di conservazione delle prove elettroniche nei procedimenti penali. We have it clearly in the criminal procedure setting. And the second one, a little bit shorter, I will give you some comments on an evolution that you see in some countries. This is not at the European level yet, about what we call, what you call in Italian, perquisizione online. I'm speaking here about, in fact, remote. Before it was computer search, but today computer is just a word for internet systems if you want. So it's our remote digital searches that some people even call governmental hacking. That means you hack systems worldwide, and those who hack are not private persons, you and me, because it also exists of course, but this are law enforcement authorities, policemen, administrative agencies, and prosecutors. They hack worldwide to get into the systems and to get evidence. So that's, of course, you can imagine, and then with the captatore informatico, I will explain that they can do a lot of things when they get into the systems in order to get evidence and steal evidence. So these are my two topics. What I've thought about it this morning, I think the best way to do it within a short setting is to use a concrete example. I will put that here on the small blackboard. So a concrete case, and I will try to illustrate what the importance is of these two instruments and why do we need them, at least why the people who have elaborated them believe they need them. Yeah? Okay. This is the European Union. I put here the Netherlands. I have here a firm. And I need, so this is the jurisdiction of course, this is the common territory of the European Union. And have the firm, I call it sounds Chinese and you'll see why. The firm is called Sunrise. And there are two CEOs, that's myself. I try to personalize things. And Mr. Wang. And we have some dirty business. Our first business, you will see we are in illicit trade, overall the main topic of the Jean Monnet. And we are, first of all, we are trading in cigarettes. So the smuggling of tobacco and the cigarettes are produced in Panama, so in Central America. And they are brought here to the harbor in Rotterdam, in the Netherlands, and from there we smuggle them illegally into the European market. You know, cigarettes are very highly taxed. VAT, custom duties and excises. That's good for 90% of the end value. So this is a very interesting, of course, a very interesting trend. Second, we are in business, Mr. Wang, of course, we are in business with China. And we import also through the harbor of Rotterdam illegal medicine, pharmaceutical products. Take care about today, 60 to 70% of the market in illegal pharmaceutical products is digital. So that means the customers buy it online and we sell it online, illegal. Of course, the products also have to come in, they have to be shipped. There's also, of course, there's a transfer of the products, but a lot of this business is fully digital. So, illegal medicine plus precursors from China. You know what precursors are? The Netherlands is the first producer of synthetic drugs in the world. They're all illegal, also in the Netherlands. For making synthetic drugs like ecstasy, there are many others, you need precursors, chemical products. The precursors as such are legal. But of course you use them to make methadone and ecstasy and so on and so on. China is producer number one of precursors in the world. China is also producer number one of illegal medicine in the world. Number two is India. So, my third and last business, or our third and last business, we are in the internet or the digital society of production of pedophilic images, hard stuff, real hard porno with very small children. Produced on the internet and distributed on the internet. We do that, I put here Latvia, so we are still in the European Union, one of the Baltic states. And here we have a service provider. It's a real one, Stripe, which is giving us store services, so hidden services, for the distribution of this material, mostly through Asia. Interesting, Stripe is a US firm. Here you see they're active in the European Union and they're based in Latvia. We come back to that. What else do I need? Of course, here our business with China and with the cigarette stuff and so on and so on. There are a lot of services which are digital. It can be the buyers, it can be financial transactions, whatever. They're all digital. We do that partially through Stripe, also, and partially we do that through one in Luxembourg. And I call it, maybe you know it, it's still not there, but it will be there within a very short time. Alipay. Have you ever heard of Alipay? Nobody? They are not, as far as I know, they're not yet on the European market, but they're very big and they will come. Alipay is the financial platform of Alibaba. Alibaba is the Chinese Amazon. That's Alipay. In China, everyone pays with Alipay on their mobile phone. So, we do that through Alipay in Luxembourg. But in a classic setting, which is in fact the setting today, if there is an investigation against Sunrise and against the CEOs, a criminal investigation, that's not so difficult here in the business. And the investigation starts in the Netherlands. Of course, you see, there is jurisdiction from third states. There are jurisdiction involved from Latvia and Luxembourg, two other European states. How will this work when we need cross-border cooperation? And we will need it, because In the Netherlands, a lot of things happen, but a lot of things happen outside. That means outside the jurisdiction of the Netherlands. Classically, you know that for sure, of course, the public prosecutors, the law enforcement authorities, the public prosecutors, will need to apply instruments of cooperation to gather evidence. Instruments of cooperation can be rogatory commissions under the Council of Europe conventions. If this is within the EU today, they can apply new mutual recognition instruments. What is the main difference between the two of them? If we can apply mutual recognition, for instance, the European Investigation Order, which should already be implemented, it's very recent. I don't know where we are in Italy, but Italy is not in my case. It's already implemented, a miracle. Not all countries have implemented it fully yet. So, if we would have between the Netherlands, Luxembourg and Latvia the European Investigation Order fully implemented, that means that the prosecutor here in the Netherlands can send out to judicial authorities, so that means to his colleagues in Latvia and Luxembourg, a request, an order. An order, of course it depends on the offenses. I think it's quite easy. I can add, of course, here elements of organized crime and transnational networks, so that would be quite easy to qualify. And then to gather evidence, then depends a little bit, of course, on what they are asking. Do they ask to have access to these service providers? Do they ask for access to other data, to judicial authorities? All that depends on it. But so it's a direct cooperation between judicial authorities. If the European Investigation Order is not implemented yet, then we have mostly to work with, depends a little bit, but it will be also with conventions of the Council of Europe. So the Mother Convention of the 1950s and its protocols. That's much more complicated because it goes through diplomatic channels. It goes to the Ministry of Justice and the Ministry of Foreign Affairs. It takes much more time. Anyway, I'm not giving a lecture on judicial cooperation. The point is that the main evidence is in the hands of service providers, Alipay and Stripe. These are just commercial firms. So, if the prosecutor of the Netherlands is sending out to the judicial authorities in Luxembourg an order saying you have to verify the financial transactions of this firm with Alipay from day A to day This is running a lot. Yeah. It's just a microphone. These judicial authorities in Luxembourg and Latvia, under the mutual recognition scheme, they have to recognize this order. For Luxembourg and Latvia, it is like an order of its own judicial authorities. So it does not make a difference, in principle, if it comes from the Netherlands or it comes from the Luxembourg authorities. However, okay, that means they will execute that to Alipay and to Stripe. What will mostly happen in practice? I think you will come back on that for Italy. Most of these firms will say, nice, interesting, but we will not comply. We will not give the data. First of all, we have commercial interests to protect our users, our clients. That's number one. So we have a business conflict. Second, Alipay is a Chinese firm. And Stripe is a US firm. So guys, if you want cooperation and data, go to China and go to the US, to the judicial authorities under the judicial cooperation mechanisms, and ask our mother firm. That's what's mostly happening. There are exceptions, but it's mostly what is happening. You can imagine the practice with China. But already with the US, this is a nightmare. Because if you have to channel this all through the mutual legal assistance conventions with the US, which are not of mutual recognition, these are the classic ones. That means you have to go through all the diplomatic channels. There are many obstacles, there are many exceptions. It takes an awful lot of time. This does not work. If the Dutch prosecutor is sending the request directly to the firm of Stripe, the mother firm of Stripe in California, they also will not cooperate. Mostly no, they will say you have to go through the judicial channels. So you see, there is an increasing importance of this. We call them gatekeepers, because they are sitting on the information, like the gatekeeper in the football, you know. Right before the gate, they all have the data behind. But for the law enforcement authorities, it's becoming very, very difficult to have access to this data. And they are essential for many criminal law investigations, judicial investigations. So that's my problem number one, at least from the point of view of the law enforcement authorities. Problem number two, and this is of course linked to jurisdiction and secrecy, by anonymity and encryption, is there might be business that is so difficult to find out, and of course for which you can never have cooperation. Here, my pornography story. Hard porno with small children. Done through hidden Tor devices. With this ghost provider Stripe. Of course they will never cooperate. Even if we find out that this is the vehicle, they will never cooperate. Because they have all interest to keep it in the dark web. That's obvious. Will Latvia cooperate? Maybe, but Latvia cannot ensure that we have access to the stored data. So there we have another problem. It's hidden. It's very much in the dark web. And of course, it's completely dislinked from the jurisdiction of the Netherlands, even if it starts here. There is, of course, a link, but the things are happening outside. So there we have a clear jurisdiction problem. Okay, I go to my first package of instruments that are negotiating now in Brussels. Negotiations which are not very easy. I'm referring here, I'm focusing mostly on the regulation. There's a regulation and a directive. I'll explain in a minute why. So the proposal is COM 2018 225 final. That's the text they're negotiating. So what is the idea on this European production order? I think we have in all states, we have orders or requests coming from prosecutors, when I say in all states, inside, domestically, in which a prosecutor or a police authority, a judicial police authority, can send out a letter, a request to a firm saying, we want this data. You have to produce this data. That's a production order. If mostly, at least in my country, if you don't produce the data under the request of a judicial authority, you're committing or an administrative irregularity or an offense. So you can be sanctioned for non-cooperation. Even, it might be that you're a third party. Alipay and Stripe are clearly third parties. Of Stripe you already have doubts, see the setting of the store devices, but normally they're third parties. But even in some countries, suspects have the duty to cooperate. Think about legal liability of firms or legal liability of legal persons. They have also the duty to cooperate to produce data. So these are production orders. What is the difference here? The production orders are cross-border. So this one, here, a prosecutor or a judge, as we will see, can send out orders not to judicial authorities, but directly to firms, which are based, I have to explain what is based, in a other country. And here we are, these are European instruments, EU instruments within this territory. So, of course, not for this one, not for this one. Orders to do what? First of all, to preserve data. In order, of course, to avoid that this data are disappearing, freezing them. Second, to produce them. That means that they are exchanged with the prosecutor's office or the judge. So there, of course, this is cross-border gathering of evidence, in this case, e-evidence, electronic evidence. What type of data? In fact, only stored data. So these instruments are not aiming at surveillance. So it's existing data. That's very important. So we cannot ask at a firm, Alipay or Stripe, could you, for the next 6 months, survey what is happening linked to this firm? That's not the aim of the instrument. So it's about existing data. That means what happened in the past. Then, of course, comes the question, what type of data? In fact, everything you can imagine. This goes from subscriber accounts, IP addresses, so access data, trafficking data or transaction data, and content. These proposals are making a difference between subscriber and account data and trafficking and content data. They see it as two different groups in the light of applicable fundamental rights, constitutional rights, applicable human rights, and civil liberties. So, to be brief, if this is about content and trafficking data, the order must come from a judge. If it's only about subscribers and account data, it can be limited to other authorities, like, for instance, a judicial police under the supervision of a prosecutor. So it could be that for certain orders, there is no decision from a judge or a court, and of course also not a warrant from a judge of liberties. So that means in the hands of the judicial police supervised by the prosecutor. That makes, of course, a big difference. Okay. Why the hell should Alipay and Stripe cooperate if they did not do it in the past? Because the union is saying it, of course not. Of course not. That's not enough. So in the regulation and directive, in both instruments and both drafts, is elaborate a system to make them cooperate. And of course you need a nexus to build up an obligation for them. Because they always said, our whole firm is outside. Which is true. They're just sub-firms. The union is saying it does not matter. You are, and this is the nexus, this is the criterion, you are offering services in the common territory of the EU. Aren't you? Yes, they are. Of course they are. That's the reason why they are there. They're earning money on the internal market. If you offer a service, there are also obligations. The first obligation, and that's laid down in the draft directive, you should choose a jurisdiction. Because it might be that they are active in different countries. You must choose a jurisdiction, and there you must nominate a representative. And this representative will be the addressees for the orders. And you have to cooperate with these orders within the European Union. You cannot refer to your main firm. It does not matter who your clients are, Europeans or not. It does not matter where the data are, because all these firms are storing data in the cloud. It might be that these data are in India or in China. It does not matter. You're offering services. You govern your data and you have to cooperate. So when we ask, you have to deliver them. Unless you have good grounds not to do so. This is, of course, refusal grounds. That's the main reason. So that means these firms have to choose a jurisdiction for this cooperation mechanism. So they say, we want to be established for this instrument in Luxembourg and Latvia or another country, and this is our representative. Okay, what does this importance mean? The prosecutor can send out such orders, of course, for which crimes? Is there a threshold? Or for which offenses? Also there, it depends on the type of data he wants. If he wants the data that are really very interfering in the private life, think about content, there are thresholds on penalties of the crimes. So not for petty offenses. I will not go into the details. And as I said, also there a judge must take the decision, at least warranting it. Important to know, of course, is also, are there other conditions? Can the Alipay or Stripe say, yeah, wait a moment, but you're sending us a letter, which is an order, a request, we have to cooperate with that, we have to give data, but you're asking so many data. It's like a bulk phishing, although it's linked to a firm and to responsibles. What I'm saying is, your request or your order is disproportionate. It should be limited in the quantity of data or limited in time. In the time, from the time setting that you want the data. Or the firm could even say, yeah, but you have means to obtain this data in a less intrusive way. So this is not the most appropriate instrument. Why do I'm using this reasoning? Because this is a reasoning of proportionality and subsidiarity. That is a classic reasoning under the European Investigation Order. So the direct cooperation between the judicial authorities. Is this in? Yes. But, of course, it will not be easy for the firm, for Alipay or Stripe, to say to the public prosecutor, to the judge and his order, wait a moment, it's disproportionate. Of course, they can try. That may not be very easy, unless, of course, the public prosecutor say, yeah, we want all the data from Sunrise from the last 10 years. Yeah, this is, of course, disproportionate. That's obvious. Next point. These firms, when they get such an order, can they refuse besides proportionality and subsidiarity? Yes, they could. For formal reasons, saying the order does not qualify because there should be, of course, there will be a standardized document, and there are a set of criteria, they are not fulfilled. So formal refusal, and then it goes back. But they can also refuse for certain substantive grounds. One of the grounds is that it would conflict with obligations they have under their home country. US and China. And the word is also used, it could conflict with national interests of their home country. So that means, here, Stripe could say, if we deliver the data that you're asking, we run into serious problems with criminal justice in the US. For instance, for violations of secrecy. Or violations of national security interests. We cannot give this data because they're protected by US law. That's the conflict. It's not a conflict between the Netherlands and Latvia. It's a conflict between Netherlands and the jurisdiction of the mother firm. That they can invoke as a legitimate reason, at least try. It's one of the reasons they can use. So you see here there is an interest. Of course, there is not only a business interest of the service providers. There's also an interest in the sense they are gatekeepers for several jurisdictions. Not only for the Netherlands and not only for Latvia, but also for their home countries. And this interest of the states, of the sovereigns, might not always be the same. It's not only the Europeans that have problems with that. Also the US, of course, the US law enforcement agencies and the prosecutors in the US, they want also data. And sometimes the data are not in the US, they're sometimes in Ireland. You know, there are many service providers in Ireland. There they just have the opposite problem. They're asking data from Ireland, and the service providers in Ireland are saying, we're not at home. Ask it at someone else. You see, sometimes we have the same interest to cooperate, but sometimes it's also conflicting because of the conflict of interests that are behind. It's not finished yet. Why? Because all these data are related to persons. This person might be suspects in a criminal proceeding, might be third parties in a criminal proceeding, witnesses. They all have rights. And not only rights of data protection, that of course they have, but data protection here, when you have a serious criminal case, of course, is quite limited to be serious. Because it's, of course, one of the grounds to limit, or to give access and to limit the data protection. But of course, they also have rights under criminal proceedings. Imagine the Dutch public prosecutor is asking data of my transactions here to Alipay and to Stripe. Must I be informed? If so, when? Do I have a remedy? So can I challenge this order? Can I challenge the execution of the order? The execution means, can I go against the service provider, which is also I'm a client there, but not only as a client, also rights under the criminal procedure. Where can I use that remedy? In the country of execution of the order, or in the country of the issuing of the order? All very important questions. The Union is presenting these new instruments as mutual recognition instruments. I'm not so sure that these are mutual recognition instruments. Why not? Because there is no judicial authority in principle involved in the second country. It's direct to the firm. Who is recognizing what? The firm is not an authority to recognize. They just execute, and then they have good grounds not to do so. So, mutual recognition between judicial authorities, I don't see it. There is an exception, I come to it in a second. Who is assessing if I have rights and if I can use it? The firm? Strange authority who says that. And mostly I will not be informed, because at least in a later stage. So the philosophy of the instrument is, I can use a remedy because my data has been transferred in the country of the issuing order. So that means in the Netherlands. And when can I use the remedy? That will depend on Dutch law. So that will mostly be when they start the prosecution against me. Then I can say, wait a moment, there are data in the file, and where is the data coming from? I didn't know it, and I do not agree, and then this is a common territory. We have a harmonized procedure for this, for gathering evidence, but the remedies will depend upon the jurisdiction of every national system. So it could be that the remedies in Italy are much better than in the Netherlands, or vice versa. So there will be a lot of differences on the remedies for the suspect, although there is a simplified procedure of cross-border gathering of evidence. My last point. What happens if the firm, Alipay and Stripe, are trying not to cooperate, so they're sending back the stuff to the issuing authority, trying to convince them of having good refusal grounds, but they are rejected. And still they don't want to cooperate. Then the text contains an enforcement regime. That means the issuing authority can ask, and here comes the judicial authority of the second state into play, to enforce the order. So it's not about recognition, it's about enforcing an order. That's something else. So that means they use the law of Luxembourg and the law of Latvia, partially harmonized by this instrument, to oblige the firm to deliver the data. If they don't do so, including with sanctions. So, sub pena, as they say in US law. That's a system that is in the text. Of course, we have a lot of difficulties, because if the firm is saying, here, by Stripe, I will violate US law, even in a criminal law sense, so I will commit an offense under US law if I give this data, then the enforcement authorities, this will be courts in Latvia, they will have to assess the interest of the Dutch public prosecutor, which is a clear interest, against interest of the United States under national security law.
A hell of a job for a judge in Latvia. Not so easy. That's what he will have to do. He must make a decision. Can the firm refuse or can the firm not refuse? And the firm cannot refuse and is not willing to cooperate, sanctions. The risk is, of course, that the US is doing the same. Last point, the idea, but we can come back on that in the discussion. You already see this conflict of legal orders and jurisdictions within the EU and outside of the EU. We have a lot of service providers inside and service providers in the US, of course, will lead to increasing conflicts. So the idea is also that, at least for citizens, non-US citizens, having data in the US, that there will be negotiated agreements between the European Union and US jurisdictions for the exchange of data, this type of data, linked to criminal proceedings and criminal investigations. I come back to that, we can come back to that in the discussion. My second point. My second point is linked to this here, this store stuff. These hidden devices for selling and distribution of pornography. So, as I said, quite a lot of countries now, including the Netherlands, have introduced or are in the process of introducing new investigative measures. So that means special investigative techniques in the criminal procedure. When it comes to gathering evidence outside of the Dutch jurisdiction, or outside, France has it already, also Belgium has it. That means that law enforcement authorities, mostly prosecutors, can access internet systems outside the jurisdiction of their home country. Mostly that is a starting point. That means you hack. Hack, of course, is illegal, but here you do it legally. You hack a digital system which is linked to the Netherlands. That can be a computer system of this firm in Rotterdam. So you get into it. And then from there you go outside the jurisdiction of the Netherlands. So you follow the links. So that means you can arrive here. If you are, of course, if you are very clever, because this is hidden. Then you hack into the systems, and then you go to the clients in Asia. So this remote digital searches is, of course, it's like entering in a home. You knock the door. You not only knock it, you also knock it down. So that's, of course, very visible, but here it's you can do it in a very invisible way. So the people which are using all these internet systems or digital systems are not aware that you are getting in. Once you are in, of course, you are in the systems. So there it's, you can do a lot of things. You can install software, good or malware. Malware, of course, is that you want to destroy the systems. Good software, they're doing things for you. And the users of the system don't see it. They're hidden. This can be very simple. They have their audio offs. They have their cameras off. You could put them on. They don't see it. So they believe everything is off and it's all on. So that means when you have a simple computer somewhere and everything is off, they can film and listen. And you believe on the system that everything is off. They can, of course, copy a lot of things, not only existing documents and information, data, but there also they can surveil. There we come from existing data to surveillance data. Because they can install software that is giving a lot of information on processing in the coming months. They can take photographs of screens, they can take photographs of the keyboard, what you're doing, everything you can imagine. And installing a lot of software doing functions. You can take the Dutch judicial authorities, prosecutors has done it in several cases, even before, so that means illegal under Dutch law, but they have confessed it. You can just take over the systems. They took over several Tor systems in Asia, which were distributing pornography, and then with warnings, and after a certain time, they closed it completely down. That's, of course, more than gathering evidence. That's avoiding that the systems can be used. They just destroy them in order to avoid further harm. So you see, this goes very, very far. So now we have, in very recent, in Dutch criminal procedure, a specific provision for extraterritorial remote searches and related functionalities. This, you can imagine, is a very, very coercive measure, and it's also very problematic. Why? Because it means that law enforcement authorities, although they are legally authorized to do so today under Dutch law, they go abroad. Though they are active in jurisdictions of other states. Now, one of the main rules in international public law is that certainly for public authorities, you can only be active in your own jurisdiction, on your own territory. And if you want to gather evidence in other states, you have to go through the cooperation instruments, of course, with the consent of the other states. Does it mean that law enforcement authorities never can go abroad? That's not fully true. We have for instance, we have the Budapest Convention of Cybercrime of 2001, if I remember well, Article 32, but that's extremely limited. So a prosecutor or a policeman, of course he can check open data worldwide, as you can do and I can do that. There's nothing wrong with it. If they're open, they're open. But these data are the opposite of open. They're extremely protected and hidden. So these are certainly not open data. And you also can go abroad in other jurisdictions with the consent of the suspect, yeah. I will not give any consent, of course. I have no reason to give consent, no interest at all. So the possibilities for law enforcement authorities to go outside their jurisdiction are extremely limited today. So they do it illegally. Of course, when they do it illegally, mostly the information obtained cannot be used as legal evidence. It can only be used as starting evidence. That means to gather legally evidence. If they do it legally, like today in the Netherlands, I will in a minute say a couple of conditions, then also the evidence obtained is legal under Dutch law. Of course, even if that violates sovereignty of third states, which is quite possible. Because you don't say to third states that you're going to do it. That's my starting point. When is it possible? Under Dutch law, the criterion is, it's a measure of last resort. You have tried everything, so the whole toolbox of criminal procedure, and you cannot get to this key evidence. It's impossible. So you're stopped. Second, you don't know where the evidence is. Of course, you have the firm, you have two responsibles, you know that there's a link with Latvia, but the evidence is not in Latvia. The stores are in the cloud. So you cannot locate the data you need. That means when you cannot locate the data you need, it's very difficult to say, okay, we will send out a cooperation, letters robbery under X instrument to country A, because you don't know the country. You don't know the country. So when you're in a situation that you really are stuck, you don't know the country, then you can use this one. For this one, of course, you must be technically very brave. We have a specialized law enforcement personnel at the Public Prosecutor's Office in Rotterdam, which is doing only these things. So, yeah, of course, you need the software, very expensive software, and specialized people. Okay, then you hack into the systems, but the prosecutor needs a warrant from a judge, a Dutch judge. Second, he needs a prior authorization by the General Prosecutor's Office of the Netherlands. So there's a special supervision on the use of this measure. Double. The judge and the highest level in the prosecutor's office. You see how sensitive it is. Do they use it? Yes, they have used it in the past illegally. We know at least about 10 cases, and of course they will use it now when it's a legal basis, when having it a legal basis for this. I'm summarizing. What is it showing? So this is showing, of course, the importance, the increasing importance of e-evidence. That's very clearly. And once again, not only for computer crimes, it's for a lot of common crimes. This here what I have, this is not, some, of course, illegal medicine and precursors here, a lot is digital, but there are also goods traveling. So it's partially digital world, partially real world. So the e-evidence will become more and more important. And you see very clearly that these gatekeepers, with the increasing importance also of the platform, not only the classical email service providers, but the financial, the fintech world. The fintech world will become a very key player in producing evidence for the investigation and prosecution of crimes. Very, very important. And so that's the reason why we try to put upon them obligations, not only of keeping the data, retention of the data, preserving the data, but also producing them under certain conditions. Of course, as I said, there are a couple of critical questions about remedies for them, remedies for the suspects, and so on and so on. And of course, one of the crucial points here is that the judicial authorities in the states of execution are, in principle, out. It's direct to the phone. The outlines, the remote searches in other jurisdictions, I think that's it's a very difficult one, because I personally don't believe that it's in line with international public law. But states, at a certain moment, they're so desperate, they just don't care anymore. So the importance of effective investigations and prosecutions are more important than the respect of big narratives of sovereignty. And they just do it alone. And I think in many cases they can get away with it, because also the states of which their jurisdiction might be violated, they're even not aware. They're even not aware. Because the information is in the clouds. And they just hack it and bring it back to the trial. And of course, it's somewhere linked to the state territory, because the information is somewhere. But the state also has great difficulty to know if they were hacked or not. The rest for the discussion. Thank you so much.